Okay, so today we're going to talk about the Second Amendment. I used teachingamericanhistory.org for the original state constitutions, as they were written before the Constitution and they would have been source material. These were the constitutions as they were during ratification of the Constitution and the Bill of Rights. There are two primary narratives behind the Bill of Rights, and really the Second Amendment in particular. One of these is that it is for militia, and that the government has a right to regulate the militia. In this case, they say that regulating arms is regulating the militia or some variant thereof. The other is that the right to bear arms belongs to the people. The government has no right to regulate the bearable arms of the people. I think that both of these are unreasonable, and both of them have their pitfalls and falsehoods, and both of them have a kernel of truth within them based upon the source material. Right out of the gate, I'm going to concede that the source material supports the narrative that the Second Amendment explicitly supports the states to form and regulate militias, or at least ensure that the militias are well trained, which is what regulate meant in the context of the Second Amendment. Nearly all of these state constitutions at time of ratification express a need for state militias to defend themselves. Several of the state constitutions, New Hampshire, Delaware, and Maryland, even exclude any mention of the people. Unfortunately for the regulation of the militia narrative, there seems to be no elaboration beyond this point for the states that mention militia and no people, as stating that there's a need for the militia seemed to be good enough for these states. Here's what it said in the Delaware state constitution: that a well-regulated militia is the proper, natural, and safe defense of a free government. There is support in some of the state's Declaration of Rights that bearing arms is an individual right. This means that the right belongs to the people. On the map, you'll see that the states that are in blue, Massachusetts, Pennsylvania, Virginia, and North Carolina, all list their constitutions that the right is of the people. These state constitutions were generally more carefully elaborated than most of the red states shown. All explicitly mark, again, that the right belongs to the people, or in other cases, they list it as every person, every man, or some other variant. All of these states also explicitly state that the purpose of this right is to preempt the formation of a standing military, as it is dangerous to liberty. One honorable mention here for a militia state is New York. By the authority of the good people of this state, do ordain, determine, and declare the militia of this state shall be armed and disciplined. Keeping with their social contract, New York actually does maintain an active militia to this day. If not for the equal protection from state and federal laws clause in the 14th Amendment, they may have been in good standing to disarm their residents in the instance that the Civil War never happened. There is more detail in their arms or militia clause than many of the other states, and I recommend you give it a read, because it does mention the individual responsibility to take up arms in defense of the state, but does not explicitly delegate the right to bear arms to those individuals. So I'm not sure how to read that. One of the other arguments against the Second Amendment is that it does not apply to your right to self-defense, and I think that this argument is a little bit disingenuous or out of step with reality. Number one, Pennsylvania's Bill of Rights explicitly listed the right to bear arms for the purpose of personal defense. But it goes even deeper to a level of natural rights. Self-preservation is explicit and implicit in many laws, legal rulings, and human behaviors. As a component of this right, you have a right to defend yourself by any means necessary. And I mean by any means necessary, except that this action cannot harm anyone except for your assailant. Natural rights are endowed by our Creator, or if you're an atheist, it's endowed by evolution, which will be borne out in my examples. A dog has less rights than a human, but if I punch a dog and that dog bites me, No reasonable person will say that the dog should be punished, even though the teeth could be argued to be more dangerous than my fist. Another example is that sometimes bears kill humans. When bears kill humans because they like the taste of human flesh, we go out and we kill that bear to eliminate that instinct from the gene pool. However, if unarmed humans cross paths with a bear cub and its mother, and the mother kills those humans, even though those humans were unarmed and not truly a threat, we let the bear live. This is because the bear was acting out its natural right to self-defense against a perceived threat. The need to survive exists within all living things and applies to humans as well. It cannot be removed. It is inalienable. The reason why we are not allowed to own tanks for self-defense is not because they are ineffective. It's because their private ownership is so rare that our likelihood to face one, or to face a threat that would require a tank, is virtually zero. Tanks are dangerous and unusual, and the fact that they are unusual means that people can delegate their right to the government to preempt a civil arms race with explicit legislation. Legislation that is vague is unconstitutional. As soon as it becomes reasonable that you may face a particular weapon, it is reasonable to arm yourself to equivalence for the purposes of self-defense. Now, there's another argument against the Second Amendment, and this one deals specifically with its grounding in racism. And I'll go into a little bit of detail here to actually test this hypothesis, because it is more testable than you might think. Now, the first way that I would test this argument is if the purpose of bearing arms was to maintain the institution of slavery, then it would be reasonable to presume that all slave states would have it. Georgia, South Carolina, and New Jersey were all slave states, but there's no mention of bearing arms in their declarations of rights at the time of ratification of the Constitution. If the purpose of bearing arms was to maintain slavery, then free states would not have had a need to declare the right to bear arms in their declarations of rights. Pennsylvania, the freest of the free states, had a right to bear arms, as did Massachusetts. Okay, so at this point, I think it's pretty clear that slavery and the right to bear arms aren't really connected, but there's one more test that we can do just to put a nail in the coffin. If the purpose to bear arms was to suppress slave rebellions, at least one of the slave states would have made mention of that purpose in their Declaration of Rights. Again, this test falls short, with the threat and concern mentioned in the slave states of Virginia and North Carolina as being the federal government having a standing military, and that the militia would fill in the needs of a standing military so that the government would not need to maintain one and threaten liberty with that standing military. Many of the slave states, I'm certain because I read a few lines going through the state constitutions, had provisions dealing with slave insurrections or the arming of African American individuals. However, these sections of the state constitutions appear to be disconnected from the general right to bear arms. If you have any evidence to the contrary, something concrete, please leave me a comment or give me a source so that I can look into it. As of my reading, I could not find anything that would support this narrative. The argument that I've seen that the Second Amendment was designed to support slavery was that it was presented at the insistence of Southern states. And this is really an odd point. The Second Amendment was added to the Constitution at the insistence of the Southern states, but the argument is more nuanced than this, as it was added by the insistence of the Anti-Federalists, which originated in the geographical South. But they were not just pushing for a right to bear arms. Among their demands were right to free press, to protest, to speak your mind, protection from search and seizure, ban on cruel and unusual punishment, and many more, which are concrete traditional, classical liberal, and classical conservative values. The right to bear arms was not some unusual demand, but a component of a broader need to place explicit restrictions on the federal government not to infringe on the natural rights of its people or upon the powers delegated to their state governments. Finally, the Anti-Federalists were not just a Southern phenomenon. As suspicions widened between the North and South throughout the 19th century, the ideological chasm widened, so a lot of the dominant Southern theories became really more Southern. But there were Anti-Federalists that were in the free states and did not own slaves. I think that the tangling of slavery and guns is partially driven by the confusion by the starting and ending conditions of the ratification of the Constitution and the Civil War, and I think some of it might be intentional disinformation. But I can't really tell which journalists and public people are presenting their arguments disingenuously and which ones are legitimately confused. Viewing the maps, you can see that there is support for the state militia narrative. But there is also support that the right to bear arms belongs to the people, and even some support that the right to bear arms is for personal defense, as it is explicitly listed in the Pennsylvania Constitution. There is little to no support that the Second Amendment was purposely added to maintain slavery. Again, while it's true that the Anti-Federalists were primarily in the South, their insistence that the right to bear arms was added to the Constitution was part of a suite of guaranteed rights. It makes little sense to me that we should assume that these Southern thinkers added the First Amendment as a virtuous amendment, but the Fourth Amendment was malevolent so that bad guys could conceal their evidence from the government after committing a crime. Likewise, adding the Third Amendment and the Second Amendments, it's not abundantly clear to me that one was added with malevolent intent, but the other totally benevolent. The Second Amendment appears to me to encompass both militia and self-defense requests from the states, not just one or the other. The expression of the amendment includes a statement of purpose, a well-trained, or in other words regulated, militia being necessary for liberty, or a free state, a free nation. The government cannot create roadblocks to prevent people from arming themselves. This is a right of the people. It is not a delegated power to either the federal or even the state governments, as that was taken out of their hands with the 14th Amendment, with one caveat. The government is allowed to call on the armed populace to fulfill their duty during time of need for the common defense. In other words, with the right to bear arms comes the responsibility to defend yourself, your kin, and your state and your nation if necessary. The right to bear arms for self-defense is not unlimited. Your right to defend yourself ends at the point that it harms an innocent bystander. Under this logic, nuclear weapons, tanks, or bomber jets would be excluded, as it is very difficult to make a case that you can defend yourself with those weapons without harming innocents. This also generally means that most bearable arms are permitted. Again, machine guns carry an unusually dangerous threat to innocent life, as in some cases they're difficult to control and may throw projectiles downrange into unintended areas. Most small arm calibers, however, are relatively easy to control to minimize the threat of harming innocent life. I hope you found this presentation informative, and I hope it opens up your eyes to a little bit more as far as the idea of natural rights and the right to bear arms in general.